Well, because it would seem that you already waded into that. When you talked about, we saw that, the Senate waded into what happened in Kogi, where there was some confusion over who should inherit the vote garnered by the late candidate Abubakar Audu. You already waded into that. You also waded into whether or not a tax clearance certificate should be part of the requirements. You already waded into that. Well, you also waded into whether or not, INEC can withhold materials, or whether people can prevent candidates from viewing, materials after the elections have been conducted if there's an electoral dispute. So why not who should bear the honors?
Well, what we said on the issue of the what happened in Kogi, there was a law, there is a law that takes care of death of a candidate before the election. And there is also a law that takes care of death of a winner. That is to say, after the election, after the results have been declared. But there is no law to take care of death of a candidate from the commencement of election up until the declaration of results, just like what happened in Kogi State. So what we came up with was that there were two issues. One side was saying that the runner-up in the first election, in the primary election, which is what played out in the present circumstance in Kogi, should take over. Another is that the running mate should. Now you could see that even the present law that takes care of death of a candidate before the election says that the election should be suspended and primary election should be conducted by the party that the candidate died and present a new candidate. Then a situation where after the results have been announced, the runner-up automatically becomes the candidate, the person to be sworn in. So we had two sides to that. So we felt we should give a level playing field for both the runner-up and the running mate. So INEC, in this law, we said INEC should suspend the election for 21 days and give the party, that is if the party intends to field, to continue with the election, to have another primaries within 14 days, and INEC should continue the election where it stopped.
But considering that the Supreme Court already waded in on this matter, why did the Senate feel the need to legislate on it?
There is no legislation to cover that aspect, no legislation whatsoever. So what we're saying is we just legislated this to take care of this situation, and we presented a case.
No, usually when there is they always say that the law cannot see every, side of the story, and that's why we have the courts to be able to interpret and even, help out wherever it is that the law, just did not see the things happen or will not see the things happen. Now, we saw a situation whereby this matter got up to the Supreme Court, and it would seem that there is some resolution as to what should happen in the event that, a candidate dies before election results are declared. Why did the Senate still feel the need to legislate?
Because, like I said, there was a lacuna, if you could remember, at that time. It was all over. There was a lacuna. So what Supreme Court did was just to uphold the election of Yahya Bello. They did not legislate. Supreme Court cannot legislate. So what we're saying is that with that lacuna, with the absence of an enabling law, so we have clearly come out with the law which says that this is what should be done. Suspend the election for 21 days, have the party involved hold another primaries to present a candidate, and if they so wish. Because there's a situation where in Kogi was the leading party that lost a candidate. It could be a losing party. And if the party still feels they want to continue with that process, then they can. But if not, then INEC has the decision to continue with the election 21 days after.
In your assessment, which one of the amendments that you made would you say is the most remarkable?
I guess there are 4 areas that I would look at. One is the use of the smart card reader. That also it's we just had to have legislation on that because it has proven to be successful in reading a card. Where we had problem with the smart card reader is tying up the biometric data of the individual to that card. We were made to understand that the smart card reader never failed to read a card. Whenever you put, if it's a genuine card, it will read a card with all the details on that card. But what it had failed to do was capture the biometrics, that vis-a-vis the thumbprint. And you could remember the Supreme Court judgment that did not envisage, they said it was the manual register that subsists, not the smart card data. So what we did here is to capture the use of the smart card reader or any other technological device. Because the smart card reader's name is just, that's what it connotes, smart card reader. But INEC is now free to use any other device or in whatever name, as long as it's a technological device in the use of accrediting, the voter. And so we were just substantiating that in the law. The second aspect that I think it's also landmark is the issue of qualification and disqualification of a candidate. The Constitution is very clear on qualifications of a candidate. Now, that brings us to what you just mentioned on the issue of tax clearance and things like that. The Constitution is supreme. The Constitution says if you have, there are certain guidelines, certain qualifications you must have